Hello everyone, and welcome back to Nova Real Estate Solutions. I'm Dwight Morris, an estate and probate specialist at Innovation Properties right here in Fairfax, Virginia. Today, I'm delving into a topic that can be incredibly stressful and costly for families: Virginia probate fights. I'm going to explore the common disputes that tear families apart during estate administration, and most importantly, I'll share practical strategies on how to prevent them. Losing a loved one is already one of life's most challenging experiences. Unfortunately, the process of settling their estate, known as probate, can sometimes add another layer of heartache if disputes arise. These probate fights can quickly escalate, turning what should be a time of remembrance into a contentious legal battle. When emotions are high and significant assets are on the line, even the smallest misunderstandings can ignite major conflicts. These battles don't just drain emotions, they drain the estate's resources in legal fees and prolong an already lengthy process here in Virginia. Understanding why these Virginia probate fights happen is the first crucial step in knowing how to prevent them. So what exactly do these Virginia probate fights look like? While every family and estate is unique, there are several common disputes I frequently encounter. Will contests are arguably the most recognized type of probate fight. It happens when someone formally challenges the legal validity of a deceased person's will. In Virginia, common grounds for such a challenge include lack of testamentary capacity. The argument here is that the person wasn't of sound mind when they signed the will. Perhaps they were suffering from severe illness, advanced dementia, or under the influence of medications that impaired their judgment. Proving this often requires medical evidence and witness testimony. Undue influence is another common claim. This is when it's alleged that someone pressured, coerced, or manipulated the deceased into creating or changing their will to benefit that individual. This often involves a dominant figure, like a caregiver, a new spouse, or even an adult child, exploiting a vulnerable person. It's about demonstrating a lack of free will. Heirs might claim improper execution. Wills in Virginia must follow strict legal formalities. If the will wasn't signed correctly, lacked the required number of disinterested witnesses, or wasn't properly notarized according to state law, it could be deemed invalid. These technical flaws, though seemingly minor, can open the door to a probate fight. Then there's fraud or forgery. While less common, these claims involve allegations that the will itself was fabricated or the signature was forged. These are serious accusations requiring substantial proof. Even if the will's validity isn't questioned, probate fights can still erupt over how assets are to be divided. This is often driven by vague phrases in the will, like "my personal items" or "divide among family," that can lead to heated arguments about who gets specific sentimental possessions, collectibles, or even larger assets. Communication is key. When an estate includes real estate, a family business, or unique collectibles, beneficiaries may disagree on the appraised value. A lower appraisal might benefit one heir, for example, if they are buying it out, while a higher one might be sought by others. A significant source of probate fights stems from assets that pass outside the will. This includes life insurance policies, retirement accounts like IRAs or 401ks, jointly owned property with rights of survivorship, or assets in a trust. If these assets are not aligned with the will's intent, it can lead to perceived unfairness among heirs. The executor or administrator, the fiduciary, holds a position of immense trust. Probate fights are common if beneficiaries believe the fiduciary or personal representative is not fulfilling their duties properly. Examples of these might include mismanagement or wasting assets, accusations of making poor investment choices, allowing property to deteriorate, or incurring excessive unnecessary expenses. An executor using estate funds or assets for their own personal gain which is a serious breach of fiduciary duty and can lead to immediate legal consequences. Allegations that there is a lack of communication or transparency on the executor's part. Failing to provide timely updates, refusing to share accountings, or simply being unresponsive can breed suspicion and distrust, often leading to beneficiaries feeling compelled to take legal action. The complaints of unreasonable delays. Beneficiaries become frustrated if the estate administration drags on for an inordinate amount of time without clear, justifiable reasons. The very best way to avoid Virginia probate fights is to engage in robust and thoughtful estate planning before issues arise. Here's how to prevent them from the outset. Draft a clear, unambiguous will. This is the absolute cornerstone. Do not rely on do-it-yourself kits for complex estates. Have a seasoned Virginia estate planning attorney draft your will. Ensure that it is precise in its language, leaving no room for misinterpretation regarding who gets what. And crucially, ensure that it's executed exactly according to Virginia law, witnessed properly, and without any question of undue influence. Review your will regularly, at least every 3 to 5 years, and certainly after any major life event like marriage, divorce, births, or deaths in the family. Consider a revocable living trust. For many, a revocable trust is an excellent strategy to bypass the probate process entirely for assets titled in the trust name. Assets held in a trust avoid the public nature and potential disputes of probate, often leading to a faster and more private distribution process. This significantly reduces the chances of probate fights over those assets. Utilize beneficiary designations wisely. For assets like life insurance policies, retirement accounts, and even bank and brokerage accounts, name your beneficiaries directly. These assets then transfer outside of probate and are not governed by your will, which can be a powerful tool for preventing probate fights related to those specific accounts. Make sure these designations align with your overall estate plan. Understand joint ownership with right of survivorship. For real estate or bank accounts, holding assets jointly with rights of survivorship means the asset automatically passes to the surviving owner upon your death. This avoids probate for that specific asset. While useful, be cautious and ensure this aligns with your overall distribution wishes, as it can sometimes lead to unintended consequences if not part of a larger plan. Address potential conflicts proactively. If you anticipate a potential conflict, perhaps a disinherited heir, an uneven distribution among children, or a complicated family dynamic, discuss this openly with your estate planning attorney. Even with the best planning, circumstances can lead to rising tensions during administration. If you find yourself acting as an executor or administrator, here's how to prevent disagreements or de-escalate potential Virginia probate fights. First, maintain meticulous records. This is absolutely non-negotiable. Document every single transaction, every dollar received, every expense paid, every asset sold, every distribution made. Keep clear, organized files with receipts, invoices, bank statements, and appraisal reports. These records will be scrutinized by the Commissioner of Accounts and are your strongest defense against accusations of mismanagement or impropriety, helping to avoid probate fights. Then communicate transparently and frequently. A major cause of probate fights is a perceived lack of information or transparency. Proactively communicate with all beneficiaries. Provide regular updates on the estate's progress. Explain any delays and promptly furnish copies of important documents like inventories and accountings. Clear, consistent communication builds trust and minimizes suspicion. Seek professional guidance, both legal and financial. Do not attempt to navigate a complex estate alone. An experienced Virginia probate attorney is invaluable. They can guide you through legal deadlines, ensure proper filings with the Circuit Court and the Commissioner of Accounts, and help interpret the will correctly. A financial advisor or accountant can assist with asset valuation, tax implications, and financial reporting. Investing in professional help early is a key strategy for preventing probate fights. Act impartially and without personal bias. As a fiduciary, your legal duty is to act in the best interest of the estate and all beneficiaries, not just your own interests or those of one specific heir. Avoid any appearance of favoritism. If you have a potential conflict of interest, disclose it immediately to your attorney, and if necessary, to the court. Consider mediation or alternative dispute resolution. If a dispute does arise, before jumping straight into litigation, explore mediation. A neutral third-party mediator can help facilitate a conversation and finding common ground. Mediation is typically less expensive, faster, and far more conducive to preserving family relationships than going to court. If it's a powerful tool for preventing probate fights from escalating. So why put such strong emphasis on how to prevent probate fights? What's the real, tangible impact of Virginia probate fights when they do occur? Well, with such disputes, there's the distinct possibility of financial devastation. Litigation is incredibly expensive. Legal fees for all involved parties can rapidly deplete estate assets, sometimes leaving very little for the intended beneficiaries. This often creates a bitter irony, where the desire for a larger share results in less for everyone. Fighting over the estate often produces protracted delays. A contested probate can drag on for years, sometimes even decades. This ties up assets, delays distributions, and creates immense financial and emotional uncertainty for heirs who may be relying on their inheritance. A court battle almost invariably creates irreparable emotional damage. These disputes are deeply personal and can irrevocably damage family relationships, creating lasting bitterness, resentment, and fractured bonds that may never heal. There's the loss of privacy. Unlike assets handled through a trust, probate is a public process in Virginia. Any documents filed, including details of the estate and the nature of disputes, becomes public record, which many families prefer to avoid. By being proactive in your estate planning and diligent in your administration, you can significantly reduce the risk of those devastating probate fights and ensure your loved one's legacy is honored peacefully and efficiently, rather than becoming a source of contention. Navigating estate administration can be complex, but understanding the common triggers for Virginia probate fights, and most importantly, knowing how to prevent them, is invaluable for anyone in Virginia. Whether you're planning your own estate or serving as a personal representative for a loved one, taking these steps can ensure a smoother, less stressful process. Now, if you have more questions about estate planning, probate, or real estate in the Fairfax area, please don't hesitate to reach out. My contact information is in the description below. If you found this video helpful, please give it a thumbs up, subscribe to our channel for more expert insights, and ring that notification bell so you're the first to know when we drop new content. Thanks for tuning in, and we'll connect again soon.